Uh, Ritvik, are you there? I think we can start in 2 3 minutes. Let's wait for other people to join.
Yes, I think we can start, Karan. Hello.
Okay. Ritvik.
I think people are joining. We can start then with the
Am I audible
revision
to
thing.
you?
Yeah, yes, yes. Hello. I think there's some problem in Karan's network. Uh, we will try to start it soon.
Okay, Ritvik, am I audible?
Yes, Karan. You can start.
Okay, yeah. Let me share the PPT and then we'll start. I hope that's visible. Okay, yeah, I think now it's visible. Okay, so good evening, guys. Today we'll be dealing with IPC Indian Penal Code. Last time we dealt with a few of the principles of criminal law. Okay, and we will continue with that, right? So just in case if you have any questions or any doubts, etc., you can unmute yourself and ask me, or you can put that in the chat box, any questions that you have, and I'll try to answer it. Another thing is that I'll try to make it very brief because otherwise, we cannot complete the entire Indian Penal Code in 1 hour or 2 hours of lecture. So I'll be dealing with only the information which is needed. Okay, so not more than that. Also, for your own reference, if you can open a PDF file of Indian Penal Code if you're on your laptop, etc., that will be good because you can actually read it on your own also. Or if you have that barrack with you, maybe you can use it to highlight the important parts. Right. So that's about it. Now let's start. Okay. So before I deal with the offenses which are there in the IPC, I just wanted to give you a brief overview of the IPC, which is there, and the most important chapters which are there, and also certain important information about criminal laws. Without those, without understanding that sort of information, you won't be able to understand the offenses. So we'll start from there. Okay, so this is a brief overview of the Indian Penal Code. These are the most important chapters that you will have to read. Not all the sections you will have to read. You should read only the most important ones. Now, I will be highlighting few important sections in my presentation today, in my lecture also. But on your own also, you can go and read. Just take a cursory look. I don't think they will be asking you, too much in detail. But still, just for your own reference and just to be on a safer side, if you have time, go through the Bare Act. It's not too difficult. Okay, so this is the overview of IPC. Now, when it comes to crimes, okay, there are few definitions that we need to understand. Okay, so crimes can be classified into different categories based on the objective behind the class and on what basis they are classified. Okay, so usually in you can say criminal law lingo, crimes can be classified into three categories. One is felonies, second is misdemeanor, third is petty crimes. You will not find any mention of these three names or any definition in the law. This is not in India. We do not define crimes like into the categories of felonies or misdemeanor or petty crimes, etc. It is defined as such in USA, right, or in Canada, in those places. Okay, but in India we do not use this lingo, but still they have some sort of application. Okay, so for common purpose or for general use, you need to understand what these are. So felonies are what? Felonies are basically your serious crimes like your murder, kidnapping, or capital punishment, or life imprisonment, or 10 years above. Most of those sort of crimes will be considered as felonies, right? Misdemeanor would be what? Misdemeanor would be the lower degree of crime. Okay, any crime which is of lower degree, probably let's say unlawful assembly, or let's say, or not even unlawful assembly which leads to rioting, etc. That could be misdemeanor, or certain minor offenses, okay, which do not have capital punishment, which do not have life imprisonment as well. Okay, as a punishment, those minor offenses would be called as misdemeanor. The last sort of category would be petty crimes or infractions. Okay, so what are petty crimes? Petty crimes are those sort of crimes, okay, where punishment which is prescribed is not of a jail, but rather it is of fine. Okay, so the nature of punishment is different in petty crimes. So maybe, for example, nuisance could be one example of petty crimes. Okay, so wherever punishment, those particular offenses would be considered as petty crimes. Okay, it's a very simplistic way at looking at this classification of crimes. Now coming to the Indian side or Indian part, comrade, is my audio clear? Can anyone respond? Am I audible to you?
Yes, sir.
Yes, sir.
Yes, sir.
Okay, okay, great. Okay, so in case if you feel that I'm not being audible, not visible, please do let me know so that I can try to do something about it. Okay, right. So this is about the classification of crimes in a general terms. Now, when it comes to India, the classification of crimes is based on certain different parameters. Okay, mostly you can find those classification based on the CRPC. So you will find the mention of those classification in the CRPC itself. Okay, you do not need to know the exact section, but you need to understand the concept, or that what are this sort of classification. So one sort of classification of crimes would be bailable offense and non-bailable offense. Okay, so we classify crimes. One way to look at it is bailable offenses and non-bailable. Now, what is bailable offense? Bailable offenses are those offenses where bail can be provided as a matter of right. Okay, in non-bailable offenses, bail will not be provided as a matter of right, but it will be provided in case if the judge decides that, okay, there is no problem with providing a bail. Okay, so that is the difference. That's how we classify bailable offenses and non-bailable offenses. You can find the list of those in the schedule of CRPC. You don't need to look at that right now. Okay, but for your reference. Okay. Second sort of classification would be warrants case and summons case. Okay, warrants case would be which sort of cases? Usually, they are those cases where the punishment is above 1 year. Now we cannot exactly identify like, because there are so many examples, right? But generally speaking, warrant cases would be where warrants are required. Summons cases would be only mere summons is required. The police, without without warrant, they cannot take up the case. Next is cognizable offenses and non-cognizable offense. Okay, so this is like you can say the third category where we can classify crimes. Okay, cognizable offense would be those sort of offenses where police on its own can take up the matter. Okay, so for example, if police sees someone murdering someone else, okay, so they can take cognizance of the matter, right? And then they can file a case, or they can file an FIR. So those could be considered as cognizable offenses. Non-cognizable offenses would be those offenses which are of non-serious nature. Okay, and it will be provided in the CRPC itself that which are these non-cognizable offenses. So what happens in non-cognizable offenses is that police cannot on its own take up those matters. Okay, someone has to go and file a case in a police station or inform the police about it, and then police can take action. Okay, so usually this non-cognizable offenses would be is compoundable offenses and non-compoundable offenses, right? Now, compoundable offenses means what? Compoundable offenses is, for example, let's say that these are certain offenses where agreement is allowed. Agreement between whom? Agreement between the parties themselves, between the victim and the accused, or the victim party and the accused party. Okay, so usually they are not of serious nature. I mean, you cannot obviously have agreements when it comes to murder or rape, etc. It's not allowed. But in very minor offenses where, for example, assault cases, etc. Okay, you may go in this direction. So those offenses can be compounded by the court. So that could be one sort of classification: compoundable and non-compoundable. Non-compoundable, as it's the opposite of compoundable, basically where your offenses, you cannot enter into an agreement with the accused party or the victim party, and the case will go on, and there will be an order, or there will be proper trial which will happen, right? Now, next is parties to crime. Okay, now this is obviously not a classification of crimes. It's rather how do we define parties of crime? Okay, because there are different terminologies which are used. Now, one more thing, in the IPC or even in the CRPC, these terms are not used, one can say, like, they are not defined in IPC or CRPC, etc. But for general purposes in criminal law, these words are used almost every time. Okay, whenever it comes to defining crimes or whenever it comes to determining a crime, these terms might be used. Even for the purpose of exam, they might ask you who is a necessary, who is an aider, who is an abater. Okay, so we need to understand what these things are. So parties to crime, very easy way to understand them is that one party, the first party would be your principal party. Principal party would be which party? The person who is actually committing the crime. Okay, the person who is actually committing the crime, that will be the principal party. Now, anyone else who is helping them or who is like somehow involved in that crime, they would be considered as, depending on the circumstances. So, for example, if someone is helping the person before the fact as in before the crime has actually happened, okay, by supplying weapons, by you can say in some sort of preparation, etc. Those people or that party would be called as accessory before the fact, or the accessory before the crime, before the commission of the crime. So that is one party, or you can classify that person as accessory before the fact or crime. The second party would be accessory at the fact. So it could be a principal. Obviously, principal has to be there because he is committing the crime. It would also include person, who is at the crime scene. Okay, so that person would be called as accessory at the fact or accessory at the crime. So that is second sort of party. Okay, the third one would be accessories after the fact. So it basically means that once your crime is over, afterwards, if someone helps you or someone helps the particular principal, the principal offender, then that third person would be called as accessory after the fact or accessory after the crime. So here the fact basically means the commission of crime has actually happened. Okay, now why do we need to define, or why do we need to determine this, categories of parties when it comes to involvement in crime? The reason is that the liability might differ. Okay, the liability might differ in all circumstances. Okay, but I mean, for that liability part, we have to look further. I'll go to that part, but just as an example of it, so accessory after the fact might not have the same sort of liability as the principal offender. Okay, but principal offender and accessories at the fact, they might have same liabilities. Okay, so basically, in easier term, जो भी crime scene पे मौजूद है, उनका liability most of the times same होगा. Now, when I say liability, it only means liability in reference to the offense. Like liability क्या होगा कि दोनों murder का offense किया है ना उन्होंने, but their punishment might differ. Okay, so murder offense है, but punishment would be different. So for example, जो murder में मान लो 15-14 years है, life imprisonment है, तो जिसका इन्वॉल्वमेंट कम होगा, मे बी उसको कम पनिशमेंट मिल सकता है, जिसका इन्वॉल्वमेंट ज्यादा होगा उसको ज्यादा पनिशमेंट मिल सकता है, बट पनिशमेंट मिलेगा किसका? पनिशमेंट मिलेगा मर्डर के क्राइम का ही. You're getting my point? Okay, so these are, you can say, you can divide this parties depending upon how they are participating in the crime. first degree would be the principal person who is doing the crime, second would be who is helping or who is at the crime scene somehow. Okay, uh, less than that necessary before, who is not at the crime scene but still helped. Okay, next would be someone who is helped the main criminal or main principal after the crime has happened. So this is how we differentiate between parties of crime and determine their liability. I hope you got it. Okay, still if you have any doubt you can ask. Okay, so this is for general purpose. You will not find these definitions in IPC. Okay, but for your own understanding. But what you will find in IPC is abatement. Okay, abatement is a sort of, you can say, it's provided in the law itself. What is abatement now? Abatement is basically when when you ask someone to do a crime. Okay, so you are an abater. So that is, you can say, law defines that party as an abater. Abater is what? Abater is someone who is asking someone else or instigating some other person to commit crime. Okay, that is provided in section 108. 108 defines who is an abater. An abater is a person who abates an offense. Okay, either by the commission of an offense or the commission of an act, which would be an offense. Okay, so basically what will be required in when it comes to abatement is that there should be an instigation, and the instigation should be for what? The instigation should be for an illegal act. Now there are several circumstances where abatement may happen. Okay, abatement may also happen. I mean, I may ask someone else to commit a crime, or I may ask someone else to ask some other person to commit a crime. That is also an abatement. Right? Now, why do we define abatement? What's the purpose behind this particular section? The reason is that if someone wants to commit crime, he will not do it. He will ask someone else to do it, and then he will say, "I did not do it. I was not even at the crime scene, so I should not be charged. I should be free." But that's not how law should work, right? A person who is actually doing something wrong, he should be put behind bars, and that's why this abating thing is there. That if you are asking someone else to commit a crime, you will be held equally liable as long as there is no specific law provided. Okay, so in those circumstances where abatement has occurred and law is not specific with regards to the punishment, the same punishment will happen as with the principal offender. So, for example, अगर मैंने किसको बोला है कि you murders person B, okay, and that person murders person B, okay, उसका liability होगा murder का. Okay, my liability will also be of murder. Because why? Because I have abated the doing of that thing, which is illegal, which is a crime. And what was that act? That act was murder. Okay, so this is what abatement actually means. Okay, so I'll just ask one question. Maybe you may try to answer it. Okay, so let's say that A instigates B to instigate C to murder Z. Okay, B accordingly instigates C to murder Z, and A and C commits that offense in the consequence of B's instigation. Okay, whether A will be liable in this instance or not. This example. What do you think? You can answer in the chat box, or you can unmute yourself and also answer. Anyone?
Sir, A is also liable.
A is also liable, right? So A will also be liable. Okay, because in the explanation part only it says the abatement of an offense being an offense, the abatement of such an abatement is also an offense. Okay, now let's not go too much in depth with regards to abatement because it's a very complex topic. Okay, but for the purpose of our examination, just understand, if you instigate someone, okay, to do a particular act or even to illegally omit that, someone who is legally bound to do something and you stop that person from doing that thing, then also it is an abatement. Okay, so you will be held liable. But one thing that is important when it comes to abatement is that intention is necessary. that you actually intended to instigate that person. Okay, so the mens rea part is still intact when it comes to abatement. Okay, and if you have abated someone, you will be behind bars, and the same liability will apply. If I were to say abatement of an illegal omission is an offense, abated act need not be committed. Okay, this is another important thing actually. So if and it might actually confuse you also a little bit this point. So for example, I have instigated someone to murder someone else, some person B, let's call him Ramesh for now. Okay, the person that I have instigated goes on, maybe he is unsuccessful in committing the murder, maybe he did not even do it. Okay, so this Ramesh is not dead, he is still alive. Even in that case, I will be held liable for abatement. I will be an abater of murder, and the liability will be what? The liability might be same as a murder. Okay, so the instigation to murder someone is very much akin to, the liability might be very much equivalent in that case. Okay, so the effect of abatement is immaterial. Okay, so the only crime that will be looked at when it comes to an abater is whether he has abated doing of an illegal thing or not. Third is person abated need not be capable of committing an offense. You have instigated someone to stab someone else. This person doesn't have hands. How will he stab? But that doesn't mean that you can go scot-free. You will still be held liable for instigation of an illegal act. Okay, abatement of an abatement is an offense that I said before. Abater need not consent in abatement by conspiracy. That let's not go into that. But it basically means that he should not be an active member of the conspiracy. If he even starts the conspiracy, that is very much akin to starting the abatement process. Okay, so this is about abatement. Now there are obviously different circumstances, and your liability might depend on it. You don't need to go into those sections. The one important section that you need to remember when it comes to abatement is 109, 108, and 107. Okay, 7, 8, and 9. 107, 8, and 9. Only these sections are important. Just read them on your own also. Okay, next, I think that was, if you have any doubt, you can obviously ask. I hope that was clear. Okay, now coming back to the IPC, the first chapter itself, the jurisdiction part of IPC. Okay, now why I'm dealing with all these things beforehand, before we start with the main offenses, is that we have some sort of context before we maybe start about explanation of murder or having discussion of rape, etc. So this is like the basic of IPC, you can say. So the first chapter, it talks about the jurisdiction of IPC. Now our IPC is actually kind of interesting. The reason is that obviously whatever crime that you do and any act which you do in India, and if that act is a crime, okay, then you will be held liable. Okay, IPC will be applied to you. Similarly, there is one interesting section in IPC, section 4. Maybe you need to note it down. Okay, it provides extraterritorial jurisdiction to the Indian courts. What is extraterritorial jurisdiction? Extraterritorial jurisdiction means that even outside India, if someone commits an act which is a crime according to IPC, okay, even in that circumstance, the court can take cognizance of the matter, and the case can, or the trial can proceed. Right. So in section 4, what it says any citizen of India in any place without and beyond India, any person or any ship or aircraft registered in India, wherever it may be, any person in any place without and beyond India committing offense targeting a computer resource located in India. So these are certain circumstances, but it basically boils down to what? That whether if it's an Indian aircraft, ship, etc. The Indian law will be applied. IPC may be applied there. Okay. If someone is attacking Indian computers, etc., from outside, IPC may be applied there. Okay. Similarly, if any citizen of India is doing something outside of India, okay, in that case also, once he comes back to India, IPC will be applied on him for any act that he committed outside. Okay, so it's not that you can use this loophole, go outside, murder someone, come back and be scot free. Although it might be difficult to prove that sort of crime, but still the trial can proceed. Okay. The second chapter of IPC is your general explanation chapter. Now there are so many definitions. So this general explanation means that the terms are defined in this chapter. Important chapter. Maybe one or two questions might come from here also. You never know. Okay, so I have identified in this particular chapter these offenders. Okay, so even if some in particular offenses it says he is doing this particular act which is an offense, that means male, female both are included. In section 10, it says that where man or woman that is mentioned, then that particular section will apply only on that particular gender. So man means men, woman means woman. So there is no interlinkage. For example, rape could be one example where it is a very gender specific offense where only men can commit rape. Okay, women cannot commit rape according to the IPC. Section 11, it talks about person, who is capable of committing a crime. So person includes a human being as well as a corporate or association or body. So those are also considered as person for the purpose of IPC. Another explanation or definition is of movable property. Section 22, it basically means that property which can be shifted from one place to another, or something which you can remove from the ground. So anything which you can remove from the ground, that is movable property. Section 23, 24, wrongful gain, dishonestly, that you can read on your own. It's not, it's important, but it's like there's nothing to explain there. Okay. Yeah. In the explanation part only, there is one very specific section which is provided, section 34. Okay, again, it is a definition only, or you can say an explanation only, okay, of the term called common intention. Section 34. What it says is, act done by several persons in furtherance of common intention. Okay, if any act, any criminal act which is done in furtherance of a common intention, then all the people will be liable, even though a person who did not do the act physically on his own, but still if the common intention is there, right, then that person will also be held liable, similarly as to the person who actually did the crime. Okay, so for example, if there's a gang and they go to, you can say, murder someone. Okay, ab usme there's only one person who has committed the murder. And now why they have committed the murder? Maybe they have committed the murder because they wanted to take a revenge upon other person. Okay, that could be a motive. Okay, but their intention was to what? Intention was to murder that person. Okay, so in that case, they all will have same liability as to the person who is actually doing the murder. Okay, so this is why this section 34 is important, because in section 37 again, this is what it says: cooperation by doing one of several acts constituting an offense. Okay, so common intention is if it is there between different people, even though they did not do the act on their own, then also they will be held liable. So this section 34 is important in that sense. Next is section 53, which is again important. Section 53 talks about punishment. that what sort of punishments will be given under the IPC under different sections. So this section 53 talks about that. So there are basically 6 types of punishment which can be provided or which can be imposed upon a criminal or upon an accused person. Death, imprisonment of for life, rigorous imprisonment, simple imprisonment, forfeiture of property, or fine. So these are the only types of punishment which can be imposed. Nothing else. There was one punishment